Welcome to Part 4, Obligations for High-Risk AI Systems. In this section, we move from classification to governance, what you must do once something is classified as a high-risk system.
The key theme is transparency and documenting it. The AI Act doesn't just ask for responsible AI as a principle, it specifies requirements that produce evidence so that providers, deployers, and regulators can check what happened across the lifecycle. We will focus on 4 core compliance duties: data governance, technical documentation, logging, and robustness and accuracy, completed with cybersecurity.
Then we look at 2 governance bridges that matter for real operations. Transparency, so deployers can use outputs appropriately, and human oversight, so a system can be meaningfully overseen by people, not just monitored in theory. At least that is the idea of the provisions of the AI Act. Let's begin with data governance, Article 10.
Legally, this is not use good data as a vague slogan. The Act requires that training, validation, testing data sets are relevant, representative, and managed through documented governance practices.
Operationally, that means you need a traceable story about how data was collected and prepared, what assumptions you made, what gaps exist, and what bias-related risk you detected and mitigated, especially in relation to the context of use of the AI system.
A useful mental model is Article 10 turns dataset choices into compliance-relevant design decisions. If you can't explain them, you can't defend the system's reliability or fairness claims in oversight. Next, documentation and logging, Articles 11 and 12.
Technical documentation under Article 11 is one of the audit backbones. It must exist before the system is placed on the market or put into service, and it must be kept up to date so authorities can access compliance.
And logging under Article 12 means that the system must technically allow automatic recording of events over its lifetime. This enables traceability for incidents, monitoring, and accountability.
In practice, documentation answers what is the system and why should we trust it, while log answers what did it actually do, when, and under what conditions. Both are required for effective post-market monitoring, at least that is the idea of the provisions. We will see how this plays out in practice. Now we are at Article 15, Accuracy, Robustness, and Cybersecurity. This is where the AI Act turns into trustworthy, concrete performance expectations for high-risk systems, which must achieve an appropriate level of accuracy, robustness, and cybersecurity. And, crucially, they must perform consistently in those respects through the life cycle of the system. The Act also anticipates a practical question: how do we measure what appropriate means? Article 15, paragraph 2 points towards benchmarks and measurement methodologies developed with stakeholders and relevant bodies. Operationally, this means you should expect sector-specific metrics and test protocols and not one universal accuracy number.
Then, Article 15, paragraph 3 makes accuracy auditable. The levels of accuracy and relevant metrics must be declared in the instructions for use. Deployers and authorities can compare what was declared against closer observation performance, especially when systems are used in contexts different from the intended purpose.
Article 15, paragraph 4 requires resilience against errors, faults, or inconsistencies in either the system or the environment where it's operating, including due to interactions with people or other systems. In practice, that pushes you towards technical and organizational measures like monitoring, fallback modes, and decision escalation pathways. The AI Act even signals a specific design pattern. Robustness can be achieved through technical redundancy, including backup or fail-safe plans.
Finally, cybersecurity in Article 15, paragraph 5. High-risk systems must be resilient against unauthorized parties trying to alter outputs or performances by exploiting vulnerabilities, and the safeguards must be appropriate to the risks.
The AI Act then effectively lists an AI threat model. Protection should cover, where appropriate, data poisoning, model poisoning, adversarial examples or evasion, confidentiality attacks, and exploitation of model flaws. Operationally, think of a security lifecycle. Prevent, detect, respond, resolve, and control, not a one-time penetration test. Article 16a. The provider must ensure the high-risk system is compliant with the Section 2 requirements, so the core technical and governance requirements we covered. Risk management, data governance, documentation, logging, transparency, human oversight and robustness, and cybersecurity. Article 16 little b is important for enforcement. The provider must indicate their identity and contact details, name, registered trade name or trademark, and a contact address on the system, or if that's not feasible, on the packaging or accompanying documentation. That creates traceability, or is at least meant to create traceability. Regulators and users should be able to identify who stands behind the system. This provision also shows that the AI Act really sees AI systems as a physical product.
Article 16c then requires a quality management system compliant with Article 17. More about that in a second. A quality management system turns obligations into repeatable products, rules, documentation, control, testing routines, change management, and post-market processes.
Article 16 litera D and E are the evidence pieces. Providers must keep the documentation referred to in Article 18, and when the logs are under their control, keep the automatically generated logs referred to in Article 19. And under Article 16 literal F, the system must undergo the relevant conformity assessment procedure under Article 43 before it is placed on the market or put into service. This is the legal gate. You don't enter the market first and fix the problem later, or at least that's the idea of the provision. After assessment, Article 16G requires the provider to draw up an EU declaration of conformity. Article 47 and Article 16H require affixing the CE marking. Article 48 on the system or the packaging or accompanying documentation. Together, these steps are the formal statement this product meets the regulation requirements, a procedure well known from product safety law.
According to Article 16I, providers must comply with the registration obligations, which helps authorities to track high-risk systems.
Under Article 16 litera J, providers must take necessary corrective actions and provide information as required in Article 20. So if problems emerge, the provider has duties to respond, not to ignore them.
So the overall logic of Article 16 is providers must build governance inside the organization, produce evidence, pass conformity assessments, and maintain accountability after market entry. Because high-risk AI is regulated like a high-stakes product with ongoing duties, not like a one-off research prototype.
Now let's unpack the important Article 14 on human oversight. Article 14, paragraph 1 is a design requirement. High-risk systems must be designed and developed using appropriate human-machine interface tools so they can be effectively overseen by natural persons while they are in use. This is a very difficult task to achieve. Oversight must aim to prevent or minimize risks to health, safety, and fundamental rights, not only under intended use, but also under reasonably foreseeable misuses as well. This matters because many real harms happen when systems drift into expected misuse patterns, rushed staff, scaled decision-making, or repurposed deployments.
The Act also signals that human oversight is partly a residual risk control, like in cases of data governance, transparency, or robustness. In other words, oversight is a safety layer, not a substitute for upstream compliance.
Article 14, paragraph 3 addresses proportionality. Oversight measures must be commensurate with the system's risk, autonomy, and context of use. And it distinguishes two ways oversight is secured.
First, Article 14, paragraph 3, litera A. Measures built into the system by the provider, when technically feasible. For example, monitoring dashboards, uncertainty indicators, or interaction designs that prevent blind reliance. Second, Article 14, paragraph 3, litera B. Measures identified by the provider but implemented by the deployer, like staffing rules, escalation protocols, training, or dual control procedures.
The most operational part is Article 14, paragraph 4, because it specifies what the humans assigned to oversight must actually be enabled to do.
First, they must be able to understand capabilities and limitations, and to monitor operation to detect accompanied dysfunctions and unexpected performances. That implies real-time for near real-time observability, otherwise monitoring is impossible.
Second, they must be aware of automation bias. This is a hard task to us by a legal provision. The tendency to over-rely on AI outputs is psychology proven, especially when the system produces recommendations for human decision makers. Operationally, this means the interface and procedures must counteract the system set becoming the default.
Third, oversight staff must be able to interpret outputs correctly, using available interpretation tools and methods. This is a concrete explanation. If outputs are probabilistic or uncertain, the organization must ensure people can understand and act on that uncertainty.
Fourth, they must be able to decide not to use the system in a given situation, so they must have the competence to decide on their own, or to disregard, override, or reverse its output.
And fifth, they must be able to intervene or interrupt the system through a stop button or similar procedures that brings the system to a halt.
Finally, Article 14, paragraph 5 adds a special safeguard for biometric identification under Annex 3.1a. Here, the AI Act requires that no action or decision is taken based on identification unless it has been separately verified and confirmed by at least two competent natural persons, introducing the Four Eyes principle.
There's also an exception for law enforcement, migration, border control, or asylum uses. This two-person verification may not apply where EU or national law considers it disproportionate. Finally, responsibility along the AI value chain. Article 25.
The AI Act anticipates complex supply chains, models, components, integrators, product manufacturers, distributors, and deployers. Article 25 helps determine who is treated as the provider and who carries which obligation in specific scenarios, especially where high-risk AI is a safety component in regulated products.
The practical takeaway is governance by allocation. Responsibility must be made explicit through traceability, change management, and contractual arrangements for evidence handover, because otherwise compliance gaps appear exactly at the organizational boundaries.
So, part 4 of our video course on the AI Act gives you a structured way to think about high-risk compliance. Evidence from data governance, documentation obligations, logging and robustness, operational safeguards through transparency and human oversight, and a clear responsibility mapping across the value chain. If that is enough for the AI Act to mitigate the risk, we will see this in practice, and we hope to see you again in our next video on oversight and governance.